Hi, this is Kelly Holiday.
And this is Jennifer Wilson, and we're doing our presentation on Jess Beard versus the Board of Professional Responsibility. Our case is cited at 288 Southwest 3rd at 838 Supreme Court of Tennessee at Knoxville. The rule that we are addressing is Rule 1.2, which is scope of representation and allocation of authority between client and lawyer. More specifically, we're dealing with the sentence that's in yellow, which is a lawyer may take such action on behalf of the client as is impliedly authorized to carry out the representation. You want to read the entire rule. We have it linked to the heading. You just have to do Shift Enter on the link, and it will take you to the rule in its entirety.
A little background in regards to our attorney. Jess Beard has been licensed to practice law in Tennessee since 1990, and at the time of the matters that we will be discussing, he was engaged in a solo practice in Chattanooga, Tennessee. In September 2003, Mr. Beard represented Raymond Clayton Murray, Jr. in a child support dispute with Mr. Murray's ex-wife, Tina Louise Payne Murray. A hearing in this matter was conducted on September 8, 2003. The trial court took the matter under advisement. On October 13, 2003, the trial court rendered its written opinion. Mr. Beard received a copy the following day on October the 14th, and Mr. Beard contacted Mr. Murray to inform him that it appeared that the trial court had found that Mr. Murray owed Ms. Murray $15,000 in back child support. Mr. Beard admitted to Mr. Murray when they spoke that he had not fully read the opinion, though. He also informed Mr. Murray that he would contact him after he had read the entire opinion. On the morning of October the 15th, 2003, still not having read the opinion, Mr. Beard informed Mr. Murray that Ms. Murray had made a counteroffer of $10,000, which Mr. Beard advised Mr. Murray to accept. He told Mr. Murray to accept the settlement offer and to deliver the settlement amount to the opposing counsel, Mr. Bill Horton, before Mr. Horton had any time to read the trial court's opinion. Mr. Murray agreed and promptly delivered the check to Mr. Horton. After paying the money, the parties signed an agreed order that day settling the child support dispute for $10,000. That same afternoon, 5 hours after the parties signed the agreed order, Mr. Beard finally read the trial court's order. He called Mr. Murray again and informed him that he should stop payment on the check because the trial court, although holding Mr. Murray owed Ms. Murray $10,500 in back child support, minus credits totaling $2,595, and also found that Ms. Murray was obligated to Mr. Murray for $14,552.38 of necessities that Mr. Murray had provided to the child.
The net result of the court order had Mr. Murray being owed money by Mrs. Murray, $6,697.38 plus interest. Mr. Beard realized he had a problem. The agreed settlement order was filed on October the 16th. This was the order that both parties had signed on October the 15th. On November the 17th, Mr. Beard filed a motion for relief as he realized he had the court's opinion and the agreed order of the parties, which did not agree with each other. So he asked the court to determine which order was in control. On December the 16th, the trial court found that the agreed order was indeed binding on the parties. Just great. Now what? Well, as you probably have figured out, Mr. Murray filed a complaint against Mr. Beard for professional negligence in the circuit court. On September the 17th, 2004, Mr. Murray filed a malpractice suit against Mr. Beard. He alleged Mr. Beard's advice to settle prior to reading the trial's order fell below the standard care of a trial lawyer, and he requested $16,697.38 in damages. The trial court went through all of its steps, discovery, everything involved in the malpractice suit, and on July the 10th, 2006, a judgment was entered by the trial court against Mr. Beard in the amount of $16,697.38, payable to Mr. Murray. This was the $10,000 that Mr. Murray had paid to his wife, that Mr. Beard told him to pay or advised him to pay, plus the $6,697.38 that she owed him after all the court's findings. Mr. Beard appealed this decision to the Court of Appeals, and in our case, the appeal was still pending at the time of the panel's hearing. On August the 4th, 2006, the Board of Professional Responsibility filed a supplemental petition for discipline following a complaint from Mr. Murray. Now, this is a supplemental petition because once the board got Mr. Murray's complaint, they realized that they already had a petition filed or a complaint filed against Mr. Beard by a Mrs. Lopez. Mr. Beard had represented Mrs. Lopez's husband in a domestic matter. He had not put down an order. There had been some issues, so she filed a complaint against him, and then so the board assigned Mr. Murray's complaint to the same panel that already was looking at Mr. Beard. But the hits keep on coming. Aside the Lopez complaint, there is another complaint from an unnamed mother in a juvenile matter. We don't know the parties. We don't know everything related to it, but we do know there was an unnamed parties filed a complaint against Mr. Beard for how he handled matters in a juvenile case. So that's 3 cases that are before the board against Mr. Beard. So the board combined all 3 complaints against Mr. Beard for hearing. After hearing all the evidence, after the testimony of parties involved, the Board of Professional Responsibility imposed a 2-year suspension for each complaint with them running concurrently. Now, our case, as you saw at the very beginning, was cited in Westlaw, and it was actually a Supreme Court opinion because Mr. Beard then filed an appeal to the Tennessee Supreme Court saying that the board had overreached, that the suspension was too much. But when the Supreme Court looked at it, they found out that Mr. Beard had these 3 complaints. There were like 19 different things that they found that he had done in these 3 complaints. And there had been some prior complaints against Mr. Beard. So the Supreme Court reaffirmed the opinion of the Board of Professional Responsibility, and Mr. Beard was suspended essentially for 6 years, which was the 3 complaints for 2 years each.